Welcome, welcome to A Taste of Justice. I'm Professor Angela Mae Kupenda. I'm a professor of law at Mississippi College School of Law, but I tell you that only for identification purposes. All views expressed here are my own and not to be ascribed to my school or to my students. So we have just 2 clips left for the civil rights lawsuits, even though we will continue with more videos on con law. Now, today we're going to talk about attorney fees and about money and justice. You see, the ordinary rule, the ordinary American rule, is that each party should pay their own legal fees. But sometimes that can be quite difficult. And as a result, justice may not occur because the person cannot afford legal representation. So some of our laws provide that for attorneys who represent plaintiffs in certain types of civil rights cases, like 1983, that they are entitled to a reasonable attorney's fee if the plaintiff's attorney prevails prevails in the case. The court now says for 1983 prevails with a judgment for the plaintiff. So the question is, why should plaintiff's attorneys receive why should they receive a reasonable attorney's fee? And this is how the court explains it. It says, well, the government is being represented by attorneys. And probably, well, likely these attorneys that represent the government may be career attorneys who are being paid a salary. Then you may have the plaintiff, the individual who was injured by the government. How will they be able to secure an attorney to represent them? The court or some of the justices have explained it this way. Government attorneys serve a purpose in representing the government. Plaintiff attorneys, where there are civil rights violations, are really serving the public, because the goal is that individuals who are injured by the government should have a recovery according to the laws and interpretations, and therefore they want to encourage attorneys to take these cases and know that they would be compensated to some degree. Now, you may be wondering, well, why not just a contingent fee? Why not just give plaintiffs' attorneys a contingent fee, a percentage based on what is won? And why even provide them anything anyway for helping individuals to sue the government? So here, I'm going to give you a couple of reasons why a contingency fee alone is likely not enough to encourage civil rights attorneys or to support them in taking these very important cases. The first one is that some of these cases take a very long time. An attorney may work on one of these cases for 10 years or longer before there is a recovery for the plaintiff, for the client. Secondly, in some of these cases, the individual is not really suing for monetary damages. They are suing for prospective relief. They're suing to make things better for other people. They're saying they just want the government to commit that they will not do this again. So if the plaintiff is not suing for money and the suit was based on a contingency fee, 30% of zero would be zero, whereas the case may take a great deal of effort. Another reason is that these cases, as you've seen in the clips, can be quite complicated. There may be a definite constitutional violation. There may be definite injuries, but still, the government officials may be entitled to some form of immunity. So therefore, there still may be no recovery. And so there may be many cases that a civil rights attorney takes on where there is simply no recovery at all. Also, there may be a recovery. The jury may bring back a verdict for the plaintiff, but the verdict may be very small. Section 1983 is a tort-like case, a constitutional tort, and for some matters, the jury may bring back a very small verdict, although the attorney may have put in many hours to effectuate positive change in our society. So, and there's this thing called a catalyst. It used to be, there was a catalyst theory, meaning that a plaintiff may file suit against the government. And once the plaintiff files suit against the government for some type of prospective relief or what have you, the government may change its ways. And the case then is dismissed as being moot. So now the court says that under the catalyst theory, that there must be some final judgment. So eliminating the catalyst theory means that if the government changes its ways, there may be no recovery for the attorney who put in the work to try to get the government to change its ways. So it gets rather complicated. And for these reasons, Section 1988 provides that prevailing plaintiffs are entitled to a reasonable, not an excessive, but a reasonable attorney's fee. Now, government attorneys, as we pointed out, are likely already receiving their salary. If the government wins, ordinarily there is no additional attorney's fee. However, if it's a case where a plaintiff keeps suing the same government officials over and over, and the court determines that it is just to harass the government, then the government may be entitled, when they prevail, to a reasonable attorney's fee, but not ordinarily. Now, as an example, I want to tell you about this case, and I mentioned it down in the notes for you to take a look at. The case is called City of Riverside versus Rivera from 1896. So in that case, 8 Chicanos attended a party in the house. Well, it was the house of 2 of them. And all of a sudden, a large number of police officers broke into the house without a warrant, used tear gas, excessive force, and arrested most of them. Well, they arrested them and charged them, but all of the criminal charges were dismissed against the individuals. So the plaintiffs hired several lawyers who were relatively new lawyers. The court refers to them as young lawyers, lawyers who were just recently sworn in. And they put in much work on this case. This case went on for about 10 years. So the young attorneys, as the court says, they were able to get a verdict. The jury brought back a verdict, 37 verdicts against the government in favor of the plaintiffs, and they awarded damages. So the plaintiff attorneys for the people who had been at the party, they then filed to receive their reasonable attorney fee for these many years of efforts they put in on this civil rights case. Now, here are the two different views. So the dissent said, notice I said it was dissent, so that lost. The dissent did not want the attorneys, the plaintiff's attorneys, to receive the payment that the trial judge believed they should have. The dissent said this: the juries brought back those verdicts, 37, but they did not give the plaintiffs very much money. The jury brought back a total award of around, I think it was $30,000. So some of the justices on the court said the plaintiffs got $30,000, the lawyers should only get $10,000. Now think about it. The attorneys had worked 2,000 hours on this case over the period of many years. If they received $10,000 over 10 years for 2,000 hours, the judges were saying they should only get paid $5 an hour, $5 an hour, because they should only get a percentage of the verdict. Now, the majority opinion, and I have to tell you, I agree with the majority. Those attorneys deserve the reasonable attorney's fee. They deserved far more than $5 an hour. That's my view. And remember, these views are my own. So the majority said, wait a minute. In California, what attorneys are making is $100 an hour. And that's what these attorneys are entitled to. And that's what the trial judge said. So that is indeed what these young civil rights attorneys received. They received a compensation of $100 an hour, kind of nice, right? $100 an hour, which was what other attorneys in the area received for their work. Now, it makes you think, right? Some of you, and I have the name of the case if you want to read more about it, some of you may agree with the dissent, that if the plaintiffs only got $30,000, the lawyers should only get $10,000, even though it's $5 an hour. You may say that the attorney fee award was too high compared to the jury verdict. Others of you may say, well, maybe it wasn't the attorney fee award that was too high. Maybe the verdict the jury brought back for the 8 Chicanos, maybe that was too low. But regardless, my goal here is for us to think, discuss, to learn. Learning takes us to knowledge. Knowledge takes us to the goals of the preamble of the Constitution, saying we the people to establish justice. So read the notes I have at the bottom and think on this issue. This is A Taste of Justice with Professor Angela May Kupenda. Thank you and goodbye.